Bueno, muchas gracias. Bienvenidos nuevamente a un panel que va a estar.
Thank you very much and welcome to a panel that will be very interesting, which has to do with the standard essential patents that is important for not only the United States but for the rest of Latin America. We have a luxury panel with Jim, Carlos, Micky, and Luiz, who will be talking about what it means to have a standard essential patent, and they will also be discussing different cases that have been happening in not only in the United States but also in the region. So welcome and thank you for being with us. Tech standardizations and trends, SEPs, We have Micky Minhas from the University of New Hampshire, Franklin Pierce School of Law, United States. Carlos Olarte from OlarteMoure, Colombia. Luiz Henrique do Amaral, Dannemann Siemsen, Brazil. Moderator Jim Bindseil from ArentFox, United States. Welcome. I apologize, but I only speak a bit of Spanish.
The panel in English. Thank you everyone for coming. And today we have one of the most interesting and hottest topics in IP law, and that's the licensing and litigation of standard essential patents. So you might be asking yourself, well, what does that have to do with me? And why is it so interesting? We're talking about some of the biggest companies in the world that are having worldwide patent battles, and ASIPI countries are now playing a pivotal role in deciding how those battles play out. So let me give you a little more detailed introduction of our distinguished panel here today. So we have Luiz Henrique do Amaral. Luiz is a lawyer and industrial property agent and senior partner at Dannemann Siemsen in Brazil, and the past president of AIPPI, the former president and current board member of ABPI, and the holder of commendations for relevant services to the judiciary power by the Court of Appeals of Rio de Janeiro and by the Federal Court of Appeals of Rio de Janeiro's Section for Labor Matters. Next to him, we have Micky Minhas, who is the IP Center Director at UNH Franklin Pierce School of Law, which has been a top 10 IP program for the past 30 years. So in his capacity at the school, Micky designs the curriculum and is responsible for many events the law school provides to its students, alumni, and the general public. In addition, Micky is a senior vice president for the Marconi Group, which is an independent organization focused on transforming the fundamentals of patent licensing through providing better solutions for sharing patented technology. Micky joined Marconi from Microsoft, where he was the chief patent counsel, leading Microsoft's patent group for 8 years. And before that, he was the vice president of patent strategy at Qualcomm in San Diego, California, developing patent and licensing strategies for their multi-billion-dollar patent licensing program. And next to me is our country host, Carlos Olarte, who is a founding partner of OlarteMoure, a 220-person IP competition law firm established in 2003. His 30-year practice focuses on patent law, including litigation, monetization, and transactional matters, and a good portion of his practice focuses on global 100 companies in the life sciences and telecom space. Another important client base includes local universities and early-stage deep tech startups. And even though he claims to be Colombian, he graduated as a biomedical and mechanical engineer from Duke University, received his JD from Chicago-Kent College of Law, and later convalidated his law degree in Colombia at the Universidad Javeriana in Bogota. Did I get that right? Yes. And I'm Jim Bindseil, a partner at ArentFox Schiff in Washington, D.C. I'm a registered patent attorney with over 25 years of experience on the prosecution side, mostly in telecommunications, video coding, software, medical device, and mechanical technologies, and do all sorts of IP due diligence and advising clients on IP matters. So everyone on the panel here today has direct experience with SEPs. So Luiz and Carlos have been directly involved in litigations, and Micky, through his current job as well as his former jobs, has done tons of licensing in the area. I've also done a lot of patent prosecution, probably for hundreds of SEP patents in the telecom space. So we really have a well-informed group, and I think this is going to be a fun discussion. And one thing I just want to point out is that we really encourage questions anytime throughout the discussion. So we have an assistant over here who, if you raise your hand, we can get a microphone over to you, and please feel free to ask questions of the panel at any time. So at this point, let me turn it over to Micky, who can give us a little bit of a background on standard setting organizations and standard essential patents.
Okay. Thank you, Jim. Good morning, everyone. There we go.
There we go.
Okay. You see here an image of the Great Baltimore Fire from 1904. The devastation was extreme. Almost the entire city was destroyed. Even to this day, it's the third largest fire that has ever been in the United States, behind the Great Chicago Fire and the San Francisco Fire. If you stay with me, this has something to do with standards. This fire started relatively small in one or two buildings in the main area of downtown. All the fire trucks in the city kind of came and started to try to contain it. The winds were high that day, and the fire started to quickly spread. And the city did not have enough fire trucks to sort of maintain that and try to control that fire. So they summoned fire trucks from nearby Washington, D.C. and Philadelphia, who sent their fire trucks to help contain the fire in Baltimore. However, the couplings, the hoses from the fire trucks from Washington and the fire trucks in Philadelphia did not fit on the fire hydrants in Baltimore. And consequently, rows and rows, over 100 fire trucks just sat there watching the city burn. And nothing was done about it. And the reason they couldn't is because the size of the hoses and the fire hydrants in Washington versus Baltimore versus Philadelphia versus other cities around the US at the time all had different standards, sizes for their hydrants and for their hoses. And right after this fire, 1905, the US government mandated a standardized size so that all of those could be interchangeable. And this started really forming one example of standards, so that different companies making different products could be interchangeable if needed. It also leads to more competition and better pricing when you can have different competitors making the same products and having that degree of interoperability. So coupling hose sizes and so on isn't necessarily the most technical, innovative thing. It's just everyone having to agree upon the same size, right? So, sort of like USB is today, right? You can have a phone made by a number of different companies, if it's not Apple, and your USB connector will fit all the other devices as well, right? So it allows for interoperability from products made by different companies to work with one another. And where we see that today is in a lot of technological fields, such as video coding, Wi-Fi, 3G, 4G, 5G, and as I mentioned, USB, and so on. So this is the areas where now the technology complexity gets higher and higher in different ones of these areas, but it is the advantage for everybody. Like, we all benefit by being able to buy products from different companies and have that all work together, right? A video that you watch, that someone uploads onto YouTube or TikTok can be consumed by any other device because it all uses the same compression and decompression technology. So there are a number of standards bodies, the European telecommunication standards, ETSI, ITEF, with other standards that have been created, standards bodies, where these organizations invite companies to provide technical contributions, and they will determine what the best technical solution is and have it be as part of the standard. So when companies are doing this, they're making these technical contributions, advancing the state of the technology, and then they'll have underlying patents underneath it, right? So that's the S on standards part, and then the standards body allows for those technical contributions to be approved into the standard. Now, within the standard, there are, I guess, maybe two big divisions to think about. One is what is absolutely essential for the standard, it must be done, and then there's optional portions of the standard, things that entities may have a choice as to what to be, whether to implement the optional portion of the standard as well. And then there's just implementation patents, which are just regular patents, patents that implementations thereof that may be used that are different than the standard itself. The standard document, again, is a technical document. It's a specification of here are the technical things, the throughput of something, the format of something, different ways of doing something, and that way it's all again for the goal of interoperation. And then last, patent. Companies submit these patents, and they will submit thousands of these patents, particularly as we get into the telecommunication standards, where there are many thousands of patents that are essential or optional to make our phones work, as an example. And these technical contributions are made in open meetings. So they'll meet all over the world every couple of months. Technical experts from the different companies get together and submit their proposal as to whether that technical submission will be accepted. That disclosure is a public disclosure. And so the companies are filing patents that underline those disclosures, typically the day before the meeting begins. And I've been in that position many times, and I think Jim still deals with that today.
Yes, we will often get a call the week before these meetings, and the client will ask us, how many patent applications can you file by Friday? So it becomes a definite challenge on the prosecution side to have the bandwidth available to help out your clients in these situations.
Yeah, I think my worst case scenario was once when there was a standards meeting in Australia and they disclosed something that they did not think they were going to have to disclose, and therefore I had 22 hours to file something in the United States in order to have it protected in light of that disclosure. So the question becomes, when to disclose, right? These applications are filed typically as provisional applications, and as many of you know, it can take years to perfect the patent rights into an issued patent. But the disclosures have to happen relatively quickly, usually within the first year from that technical meeting of the disclosure. And so what happens is, as many have drafted, you draft very broad claims in the beginning, and really broad claims look essential to standards, and during prosecution that may change, that may not change. So companies declare those patents very early in the process, but then there's no sort of de-declaring process that goes on for patents that may not read on the standard anymore. And this causes a set of issues in terms of those who are implementing the standards, given that the standards disclosures the standards submission process is set up in a way to encourage you to disclose very early on, but that encouraging of disclosing very early on also leads to the problem of having so many disclosures that the implementer companies have a hard time distinguishing what is actually essential, what is optional, and what is not even essential at all. So, and there have been cases some years ago, probably 20 years ago now, in the Rambus case where companies' patents were found to be unenforceable because they did not timely disclose their patents. And in the Qualcomm-Broadcom case in the 2006 timeframe, similar issues came up in the video coding space in terms of not timely disclosing patents to the standards body. And so again, because of these various cases, companies are again more and more encouraged to disclose early and often as possible.
So, Micky, one question for you. You described the process, the standard setting process, in a pretty simple manner. Seems pretty easy. But in reality, I think there are, multiple competitors involved in trying to set these standards. So how does it work in reality when each company has multiple engineers and they're trying to agree on what is the best course of action when everybody knows that, oh, you have patents that are underlying your suggestion, you have different patents underlying your suggestion, you have different patents underlying your suggestion. How does it actually get resolved?
Yeah, and it's a good question. And in reality, I think there's a tension between the technical best solution and then the business interest of having patents that read on those technical solutions. And so there's a lot of negotiation that takes place. There are hundreds of companies that are disclosing patents to the standards bodies for getting those technical submissions submitted. And for example, when I worked with Qualcomm, and Qualcomm is well known for having probably one of the top 3 portfolios in the world with respect to standards essential patents on cellular communications. Often the submission, if made by Qualcomm, would often get rejected by other companies merely because it's from Qualcomm, and sometimes one would partner with another company to have that same technical submitted by another company or in collaboration with another company in some sort of joint submission to avoid the political tendencies to reject a technical submission merely from who it came. And so there's a lot of negotiation that goes on, but I think the engineers involved really struggle with the technical best solution and what's in the best interest of that company, and trying to resolve all of that. Now there are many company submissions that have great technological leaps. I mean, think about how your phones have worked. Smartphones have been around for 15 years now, right? About 2007, maybe a little longer. Like the first BlackBerry devices, maybe in the early 2000s, so perhaps 20 years. Think about how, for example, how you watch a video in 2002 on a mobile device versus in 2022, and the amount of technological innovation that had to go to support being able to do that, and the throughput, and all the new businesses that have been enabled because of those things, right? There was no TikTok, there was no Facebook, there was no Uber. All of these things have been enabled by these technologies that we rely on the phone.
Yeah, it's very interesting. Well, hello everyone. Thanks for coming, and I would like to begin by thanking ASIPI to invite me to be on this panel. I would like just to interject very quickly, just to give you an example of what you are highlighting in terms of the complexity of the negotiations. If we see right now the 5G technologies, there are more than 250,000 patents that may apply as standards. There are 450 functions that are claimed to be standards. If an implementer, which means one of these companies that will be certainly utilizing these technologies like Apple, Samsung, and others, they have to review more than 10,000 pages of documents just for the basic information on the standards. So it shows how complex these negotiations can be. And for instance, I've been involved in one issue where we have 3 different companies claiming the standards for the same feature to the same company. So it becomes highly complex, all the negotiations.
Yeah, for sure. And really what the big issue is part of the benefit of the bargain, which Micky's going to talk about here.
Right.
Yeah.
So for a given standard, they'll have a set of rules as to what to do with the underlying IP that may be covering the technical idea. Some standards are royalty-free. A lot of internet protocol standards are royalty-free and sort of mandated as being royalty-free. So if you make a technical submission, you are foregoing your any intellectual property rights you have underlying that technical submission. In the telecommunications areas, in the video coding areas, all of the highly lucrative areas, there is a commitment made by companies making that technical submission as being either typically a FRAND commitment, F-R-A-N-D, and so and then RAND, it's a similar, reasonable and non-discriminatory, right? Or fair, reasonable and non-discriminatory. And there are cases that discuss what is the difference between reasonable and non-discriminatory versus fair, reasonable and non-discriminatory. So there's implied, but basically is, you know, there's kind of a one-way agreement between the company making the technical submission saying, hey, I will make this technical submission, and in exchange for that, I agree voluntarily to license this technology on fair and reasonable terms. And so it's a kind of a third-party beneficiary type of contract, right? Those who are implementing should be able to rely on this company saying, I am, you know, willing to license this on fair and reasonable terms. In exchange, you have the standards essential patent. And the complexity that Luiz highlighted, I think, is particularly important, because if you have that many patents and that many parties relying on that third-party beneficiary agreement, you can imagine where the issues may lie, right? And when you have words like fair and reasonable, I think it, you know, sort of highlights, well, what does company number 1 versus company number 2 versus company number 250 think is fair and reasonable? Okay, so this is probably both ends of the spectrum, right? So one side will often argue a reasonable licensing rate is a rate charged on licenses which would not result in an unreasonable aggregate rate. So as Luiz pointed out, you know, if a given company believes that their rate should be X and they have to deal with 249 other companies, you know, what is that aggregate rate going to look like, right? And often that rate would be determined to be unreasonable in light of what that ask is. So that's sort of one side of the argument. The other side of the argument is, hey, these are sophisticated companies, arm's length negotiation, reasonable is whatever the two parties agree to on a arm's length negotiation, right? And so they'll hear that side of the argument as well. Now, all these 250 some odd companies aren't necessarily treated equally, right? There are some companies that are very large, very sophisticated, have very big patent portfolios, have been doing this for 20 or 30 years, and have substantiated large portfolios. Others are small, little 1 or 2 or 5 patent holders, and may not have even participated in the standards body, but claim to have a patent that reads on that standard. So I think that more or less represents the two sides of the argument. The implementer saying, I don't even know how much to charge this first company unless I know how it fits in to how I should be thinking about the whole ecosystem and what my aggregate rate be. And the strong patent holder saying, I don't care about those other 250 companies. I have a substantial portfolio. We're sophisticated. Let's just figure this out.
All right, so now we've kind of established the baseline here, and we're going to get into the good part, which is the fight. So before we do that, I just want to interject again. Does anybody have any questions? It's kind of, the lights are kind of bright, so I can't see any hands here. Now I understand how Juanis must feel up on the stage.
I think we have none.
As an incentive, the first person to ask a question will receive either this Juan Valdez sample pack of coffee or this pack of Jet Chocolate candy bars. And I'm from Pennsylvania in the United States, the home of Hershey. I love Jet. Don't tell anybody back home that, okay? So, first person, you get your choice. These two.
Patrick.
The next,
Patrick, I
the
think.
next 4 people also get chocolate. So, please. Yes, all right.
I have a question.
You can't just ask us to repeat something. That's not a fair question.
Standards being established. It wasn't effective at incentivizing the industry to truly reach a consensus. Think back to the WCDMA licenses. You know, China goes its own way. You had 4 different cell phone protocols worldwide at the same instant, okay? So the system has had a very positive effect. But there's a lot of talk, you're talking about hold up and hold out, that it's a contract. Okay, I've been practicing commercial law for 40 years. It's not a contract. You don't have the consideration and you don't have a price. You've got an agreement on what's going to be the cap for the price, and that's literally all. So what you have is a litigation, and I've litigated many of these cases as well. Most of the litigation is not competitor on competitor cases. It isn't coming out of the negotiation. It's secondary patents that end up in the secondary market and are picked up by a troll or even a big company like IV and are then asserted against a telecom that adopted the technology 5 years earlier with no knowledge of that patent. So can you talk a little bit about the transparency of this system? Part of the thing I see as a trial lawyer is that tech doesn't even look at the patents that are out there because the quality of a lot of those patents and the nomenclature that's used and the syntax makes them almost unsearchable. So the system isn't working because of a lack of transparency. So when you talk about hold out and hold up, can you please address some of the transparency issues here? Because I think the poor quality of a lot of these patents prevents competitors from looking at the competitors' patents. You don't get the benefit the system's intended to provide, and what you get 5 years later is a lawsuit that comes out of the woodwork.
I told you that was exciting, right? So I think we are going to hit on some of those issues, but I don't, Micky, do you, or Luis, Carlos, do you want to respond to any of that commentary right now?
I think Micky might be able to
first
give
of
a
all.
better general overview, and then I'd love to say something about it. Sure.
Sure. Yeah, happy to start. So it is a third-party contract that's been recognized by many courts all over the world, the U.S., U.K., even in China, it's been recognized as being a third-party contract. However, the question is whether or not it's fair and reasonable, right? And that system can break down. So, for example, in Europe, you know, one has to make a fair offer in order to be determined to be a willing licensee, right? And so we have talked about concepts of willing licensees and unwilling licensees, and that usually it goes towards the sorts of remedies that are available to it, right? So there's a big question as to whether a royalty itself is adequate enough in order to satisfy the patent holders, fair rate of return versus injunctive relief. And honestly, it's a mixed bag around the world, depending upon the jurisdiction you look in. It may or may not be available as relief. But I think one of the bigger issues to think about is the company, and this is the hold up, hold out issue, sort of taking the legal advantage of the legal system in that country in either the hold up or hold out type of case. Your question on transparency is an interesting one, and I totally agree with it, right? Like, as I mentioned in the beginning, the large volume of patents that are filed make it and when they are filed compared to when they issue really goes to that transparency issue. It's really, really difficult for implementers to try to determine which patents they need to take a license to and which ones they do not. However, the other side of that argument is, look, if I have one patent or two patents, yes, you can go ahead and question it. I have thousands of patents, and I've shown you lots and lots of claim charts. How much do you need? And are you just using the system and using the lack of transparency as a reason to continue to hold out? And I think that's a legitimate side of the argument as well. Also, the laws have changed dramatically over time. The laws around willfulness have changed. The laws around And so 20 years ago, one would do patent clearance searches, at least in the United States, because you didn't want to be a willful infringer and have treble damages against you. Those laws have changed dramatically over the last 20 years, where there's no need for large tech companies to do clearance searches anymore, because you can deal with the legal fallout at a later point in time without the consequence of the willfulness.
I believe that before we go any deeper into this discussion, and I will come back to Patrick's point, I think, Carlos, if you could explain the holdout situation to our audience, because we're already discussing the issue without presenting the issue.
Sure. And thank you for the question. And by the way, speaking for myself, I am Ericsson's attorney in the Ericsson Apple case in Colombia, which is the one that, for 5 months, iPhones were not able to be sold in Colombia because we got an injunction. It just got lifted yesterday. But for 5 months, that's the practical effect. So if you're asking why we're talking about here, most Colombians, because I've seen it in the news, Apple could not sell an iPhone in Colombia. For a lot of Americans, that's just really weird, because getting a preliminary injunction in the US because of a host of different reasons just looks weird. What is hold up and hold out? If you have a patent, one of the things you learn early on is it's a right to exclude. So if I don't want to share my technology with someone, I don't. And I can hold up technology advancing by not sharing that technology. I'm oversimplifying like crazy, but hold up is essentially that capacity. And you can kind of figure out that in this scenario of standard essential patents, if you did have a patent, you are in a position to block, right? So hold up is that legal argumentation whereby I am preventing and using my patents to obtain an undue leverage, typically in negotiation. At least that's the story, right? Holdout, on the other end, is the implementer, the person, the phone manufacturer, that has to adopt this technology because it has to. If I want to call my iPhone as a 5G iPhone, I have to comply with the 5G standard, right? And that means I have to use all of the patents. I'm not going into the obligatory. What are the ones you mentioned? Not the implementation patents. The ones that are covered by the standard, but they're the ones you have to, the core ones, the essential ones, versus in 5Gs and 4G. Most of they're all obligatory basically. But if I know I have to use those patents and I am negotiating a license, typically this involves negotiating a license, right? And I say, hey, under your ETSI obligations, which are French contractual obligations, right? Patent owner said, you are taking the obligations to license your patents under a FRAND rate. Let's figure that out. Let's take 10 years to figure it out, right? I will eventually pay you. I'll pay you with interest. You're gonna be okay. That's holdout, because while you don't get paid for 10 years or 2 years or 15 years, you're suffering, right? You're gonna get paid eventually, but your CEO has to go before a board every 3 months for a quarterly report, and after the 5th time, it sounds pretty crummy, and what are you gonna end up doing? What are your shareholders gonna say? Drop your rates and take whatever they're giving you because we're bleeding, right? That's holdout. So that's the other extreme. I think those are the two. And just a quick note, maybe going back to Patrick's question, just a very small part to answer. I think you have to take into account that a lot of discussion, especially the examples we're going to be using today, occur as part of negotiations where it's not, I'm going to look at 10,000 patents overall. It's the patent holder will provide a set of claim charts. So I'm going to choose my top 100, my top 300 patents, take a look at them, let me know, come back, no, this is not essential, this was invalid, let's talk about this one. And additionally, something very important, in at least Apple Ericsson, we're talking about companies that had licensing agreements twice already. 1, 2, they're going on the 3rd right now. So it's not like this is out of the blue. This is also very well known between the parties. So I'll stop there, Luis. I think you probably have.
Well, just let me make 2 quick comments before even addressing the question. One is there are 2 ways based a patent can become a standard essential patent. One is if a standard setting organization, an SSO, declares it to be essential for a certain function, feature, or technology. And then there are these organizations that are, they certify these technologies, and they try to organize which patents are really. This is one way. The other way, it is a self-declaration by the patentee. So one is an organization that certifies, checks the information basically, or supposedly should check the information and declare that patent as essential. The other is the patentee come out and say, well, I declare my patent to be a standard. And then I want all the benefits of essential, standard essential patent. One of the main, I mean, we're not coming yet into litigation, but one of the main benefits of having a patent declared as essential is that you reverse the burden of proof in case of any infringement. So you have an assumption that the patent is being exploited. If you have the product and the product has that function or feature, there is an assumption. So it's a great benefit. You don't have to prove infringement in litigation. So this is one main reason. So why companies would come out of the blue and say, my patent is essential? Because they get a huge benefit, not only in terms of a license, but in terms of the right of exclusion, as Carlos said, because now I have to come out. So when we go into the hold up means the patentee, they may, I will probably not use the right word, but the word will exemplify very correctly, hide the application or hide the patent. Wait for the implement to bring the product to the market, and then they, hey, wait a minute, I am self-declaring my patent to be essential, and you are using my product that incorporates my technology, and now you have to pay me. So this is what typical hold-up situation would be. The hold-out technology, the situation is where the company says, well, I'm going to launch the product no matter what. I go to the market. I don't care. I don't negotiate any license, and I wait to see what happens. And what happens, I will deal with the situation. I may pay or not, and I may litigate or not. I may ask you. A basic rule of the patent law is the patentee has to prove infringement. So you have to go into the claims of the patent, see if the claim is actually exploited or not. You go into detail, you file invalidity actions because you find some anticipation technology. So this is the typical situation of a holdout. I don't care. So the point that I think Patrick has mentioned, it's called basically a patent ambush, where there is no enough transparency, there is no enough information. Sometimes this passes.
Y en algunas ocasiones eso entra en juego con ciertas compañías que ayudan lógicamente a comenzar el proceso.
But then it's a big surprise. That creates how much difficult sometimes this situation is, because, and you don't even go into the transparency, Patrick. If you look into the 5G, 254,000 patents. So that's a nightmare for an implementer. But on the other hand, on these 250,000 patents, there are some very important essential patents. They're essential for the market. They're essential for the technology. And the whole difficulties, and I believe that this SSOs, the standard setting organization's role is exactly to try to organize that. At least that's my perspective on this situation. And I hope we addressed your question, Patrick.
Well, and Luiz, maybe you could, yeah, it's still available, guys. Patrick. He declined it. Yeah.
He preferred the chocolate.
Yeah, we'll get you that afterward. But Luiz, I think there's another example of holdup that maybe you could elaborate on with regard to someone approaching an implementer, a device maker, with unreasonable demands.
Well, that's the other things that sometimes happen is that you have a situation where, and we start talking a little bit about our region, because I'm involved in all these disputes and transactions in Brazil. Sometimes you see some companies that prefer not to go into the friend. Some countries, they have a very good understanding of all the rules concerning the friend licenses, the essential patents. This is already well developed. In our region, at least if I talk from my side, from Brazil, that's not so well developed, and actually it's not developed at all. So there is sometimes a situation where a patent owner, well, since Brazil has no legislation, no regulation, nothing dealing with standard patents, no rules for friend-rand terms, I'm going to file a regular patent infringement case, or I will enforce my patent. I shouldn't say yet the litigation. Litigation is the next stage. I want to enforce my patent as a regular patent, and I want a royalty that may be higher than what I've been discussing under the friend terms. That's the other situation that may develop, is that they may opt in our countries. Some companies may opt, and actually the first standard cases in Brazil, they didn't start as SEPs at all. They were filed as a regular patent infringement case. And as a regular patent infringement case, of course, they filed for infringement, preliminary injunctions, all that. But at the end of the day, they wanted to enforce in Brazil a royalty rate that was higher than the rate they had in the U.S. under the friend. So that's the situation. And you have even much more complex situation. This is a case in Brazil, it's been years ago, about the caller identifier function in the cell phone. So this company had a patent for a caller identifier function on the regular line phone. And this patent was enforced. So when the cell phones start having this function, without claiming to be a standard, they filed for the infringement, saying basically, well, any company, any product that has under the telecommunication network a caller identifier function would be under my patent, and then I will enforce it with my terms. Of course, this was a huge confusion, a huge litigation led for other discussions, especially because the patent was for a line phone, was not for a cell phone, and they were trying to develop the doctrines of equivalence to say, well, it's the same thing, but now it's without a line, but it's the same function. So this shows how complex it can be if you have a broad patent with a broad claim. And then, in the middle of this litigation, there appears all other these patentees that had for cell phones patents for caller identifier functions. So it can get very confusing from the standpoint of an implementer.
Yeah. So Carlos, how has Colombia become a player? How do they treat standard essential patents?
We don't have anything special for standard essential patents. We just, have patents and patent infringement. And the way I think this started off, and just to be clear, the first case we've ever had in Colombia is Apple Ericsson, started as soon as the license expired in January 14th. So January 17th, there was a suit filed based on 14 different patents in Colombia. How have the courts treated this? And I think there's been a line of sophistication that's been developing, which is kind of what you expect when judges start to deal with it for the first time. You have two types of judges that can hear a civil case in Colombia, just your regular circuit court judges in Bogota in our case, and the superintendents of industry and commerce. Everyone thinks the superintendents of industry and commerce, those are like the ones that know about it. I'm not so sure anymore, honestly. So, and how has that developed? I think initially the patents, the regular patents, and you follow the rules for the grant of a preliminary injunction, right? You have to show you own the patent, that there is a valid presumption of infringement, right? And as far as a preliminary injunction, that there's, that the delay in granting the injunction is important. You can also look at it as an irreparable harm requirement. First judge that granted this just went through the requirements and granted. A whole bunch of other judges didn't grant. One of the arguments was, well, I'm not going to go into the ones that just had really weird reasons, but a lot of the ones that did not grant initially, I think, were basing their examination on this is too complicated, it was insufficient, right? And the one that did grant, and where the Court of Appeals just reversed, was that based on the information originally provided, the court said that was correctly granted. However, based on Apple's new evidence that was provided in the reconsideration action, kind of shifted the needle over a little bit, and therefore I'm going to lift the injunction, right? And we have another appeals court on a trial court that did not grant, now says, it was correctly, the decision to not grant the PI was correct, but I'm going to reverse, but I'm going to grant a preliminary injunction, not an outright ban, but trial judge, you need to set a royalty, right? Like a running damages while this eventually gets decided in the final decision, right? So that judge is saying, yeah, there is infringement, but in the meantime, I'm not going to grant an all-out prohibition like the other judge, Judge 43 did. Here we're going to grant a PI, a preliminary injunction, but it's going to be a damages style sort of thing. So what I'm saying is, again, this level of sophistication that's rising, where judges are understanding, one, these patents are a little weird. They're getting that. They're saying there's this FRAND obligation that the patent owner has, and that's what's making it weird. I think the next step is understanding, all right, there's this running damages, but for how long? Are you going to force a company to last for 3 or 4 years and be able to sustain infringement during those 4 years while you negotiate? So that's the holdout argument. We may never get to that issue because, at least in this particular case, as many of you know, right now there's jury trial in Eastern District of Texas. The jury has to say, is Ericsson's FRAND offer legitimate? So that might, help the parties negotiate. But in the meantime, in Colombia, and here I'll close off my comments, in Colombia, in Germany, in the UK, in Belgium, in the Netherlands, in Brazil, why is there this associated litigation? I mean, that's a big question too, right? And again, this is part of global litigation. And I think we're going to go later into why Colombia, why Brazil. But this is part of a concerted effort, and this is getting people to sit down to the table. So going to holdout, if you're a little guy that wants to license your patent to a person, an implementer, it's difficult many times to get them to sit down, right, unless you litigate. And then the question is, where am I going to litigate? Is it just the U.S.? Is it U.S. and a couple of other countries, and why those other countries? And eventually you get to, why do I choose certain other countries, right? Which I think brings us to the table here.
Yeah, exactly. Yeah, so just to summarize, you know, Brazil and Colombia, because of the way their IP laws and patents are litigated, they have some advantages that you can't get necessarily like in the US or some other countries. And maybe, Micky, you could kind of explain, like if you're managing a big patent litigation, how do you kind of look at it from a worldwide perspective and, you know, identify what kind of strategy you're going to use, and maybe we can kind of go into the injunction part of it from there.
Sure. Yeah. So
Before that, any questions? Anybody? It's really good. Come on. All right, go ahead.
do we get it too if we ask questions one another?
We're going to have to eat all this chocolate if you guys don't start asking more questions.
Sure. So, you know, as mentioned by both, you know, these battles that are going on in different countries are part of a larger war that's worldwide, and so it's multi-jurisdictional litigation, and there's again kind of an inherent conflict or problem in the system in the sense that every court's jurisdiction is domestic, of course, and the disputes are worldwide. And how do you harmonize a worldwide dispute when domestic courts are limited to domestic decisions? And that, you know, lends itself to finding the right forum, whether you're the plaintiff or whether you're a defendant. What's the right forum? What's the right country that where you can apply leverage in that worldwide dispute between them? I should say something about the costs involved in something like this, right? When you're in these multi-jurisdictional litigations, you know, it's probably at least 10 plus infringement suits active around the world, usually a couple of antitrust disputes as well in different jurisdictions, and a pipeline of the next cases that you plan on filing in jurisdictions all over the world. In the mid-2000s, when I was involved in things like this, our legal fees exceeded $1 million a day for years, right? And so you can only imagine what it's like today. It's probably closer to $2 million a day per party in operating.
Do you see these litigators licking their lips right here?
So it is high stakes. It is, and the reason it happens in this field is there are billions of devices, right? 1.3 billion devices sold a year in this market, and companies making, you know, large sums of money. In some ways, a little unsympathetic. It's a problem between trillionaires and multi-billionaires, and this dispute. On the other hand, it's a substantial amounts of money involved.
Micky, we have a question.
Thank you. Sorry for doing it twice. What you've just described is an invitation to what economists would call efficient infringement. Okay, that's the problem. I understand your point, and I agree that some courts have said it's a contract, but I was a commercial lawyer for 40 years. It's not a contract. There's no agreement on the two sides are exchanging. There's a framework that some courts have said, okay, it's a contract, so we'll go forward and decide your dispute. My question is, you've got a lot of very good international bodies out there. So 20 years, like I mentioned before, for 20 years the system didn't work because it wasn't robust enough. Now it's just enough robust that it's working and giving us good, effective consensus standards. The fallout is I've got efficient infringement and trillions of dollars worth of litigation worldwide, to the point where now courts are doing anti-injunction, anti-suit injunctions, all kinds of garbage that is really not helpful. So my question to the two of you that have been in corporate at times, why can't you take the next step when you're in these meetings and try to get a little more of a framework, a little more of something that looks like a contract? You've got bodies that can make these decisions in a neutral, acceptable way. WIPO's arbitration system, International Court of Justice, International Court of Arbitration. You've got trusted groups that could deal with this competently. Or you could do what I loved as a litigator is what the CD guys did when the Sony dispute years ago with Philips. They couldn't agree on how to resolve it to the CDs. So they picked one engineer who was a neutral arbitrator, and then you had to climb the mountain in upstate New York and go and beg the master what your rate was. But, I mean, it's weird, it was a pool, but it worked. Why can't corporations participating in these things take the next step and do something a little more definitive and eliminate millions a day in expenses?
Excellent question, and you're getting closer to where we'd wrap up. There are tools, right, or platforms that work in different industries to resolve this, right? The video coding industry, audio coding industries, and the company I work for, Marconi, has this for the automotive sector. So these same 3G, 4G, 5G technologies limited to the automotive sector, right? Where a royalty has been agreed upon, and 50 some odd licensors and 80 some odd licensees all agreeing upon a payment. So my personal view as to why it has not worked traditionally in the cellular ecosystem, the mobile handset, is you have to add a zero to all of these numbers. The disputes are that much larger, and even though even though the costs that are involved, it is still more efficient to litigate than it is to resolve an issue at a dollar value that either party would find to be unacceptable. One of the things that we did at the law school last year is we invited a large number of licensees and licensors to a conference that we had in Bretton Woods to discuss this very issue. Why can't you come together at the table? And so we had companies like Qualcomm and large patent holders on one side. We had Microsofts and Dells on the other side. And I think one of the more intriguing things that came out of that was statements such as, this is the first time we've sat in the same room and actually talked about these things outside of the context of litigation. I mean, what happens is sort of the reasonable arguments that folks are willing to make in a non-litigious environment are very different than the types of statements that you're making when you are in a litigious environment, right? People go to their extreme positions and are a little less willing to come to the middle once you're in that litigating event. That's my opinion, but I'm not sure if others have another view.
Let me make a quick comment on that. At least from the Brazilian perspective, is that when the disputes arise in my part of the world, there is already a global litigation going on. This is a dispute that's multi-jurisdictional. So it's very hard for a Brazilian court take a proactive approach to attempt to have somebody to mediate or arbitrate the solution of the problem. In fact, there was one of the cases where the court was willing to do that, and the court asked the parties to participate in a mediation process. And both parties disagreed. Both parties didn't want to go into that. One, because they had already, let's say, one central litigation where the FRAND terms were already being discussed. Second, it would be extremely awkward for the companies to sit down and resolve in one single jurisdiction while there is this whole multi-jurisdictional issues happening. I can tell you that the court was very disappointed that both parties in this specific case disagreed. And in fact, if you take just Brazil, for instance, we have several cases where this is discussed as regular patent infringement cases, as we don't have any laws on standard patents. But right now, there are 13 major cases of global that kind of spilled over to Brazil, and in none of them there was any chance of a mediation or solution.
And before I get your take, Carlos, we do have a question. Finally, someone who wants to claim the coffee or chocolate.
Hi, it's a quick question. There's a way to get a globally agreement, or you have every time to fight in each country? And another question, also a result in a country trial or litigation affect other countries?
Those are great questions and actually works exactly into what we were going to talk about with regard to the, the multi-jurisdictional effect of all the litigations and anti-suit injunctions. But I don't know, Carlos, did you want to kind of comment initially, and we can we can talk a little bit about the anti-suit injunction real quick since we're running close to time.
Yeah, I think just as far as a global resolution, typically you have our parties trying to negotiate, and many times the parties internally have different groups negotiating the license versus the assertion groups or the litigation groups, and what they're gunning for is a global solution. The litigation that you see is just part of the overall strategy. And the way I looked at Patrick's question, I was thinking, are you suggesting we all play nice? And I think, litigation does push you in that direction, but in the end, the litigation is also a reflection of what the parties believe are their truest, best chances is having courts decide. And then goes directly to your second question is, yes, those decisions in other countries do play a role in incentivizing, the parties to sit down to the table. That is a very important part to get the parties to move. When the license expires, right, the parties have usually tried to start negotiations to renew the license, for example. Many times with litigation or the impending litigation that comes up the day after, right, is what moves the parties to also, negotiate a little quicker, right? And those huge amounts of money that Micky was throwing out is part of the incentive, right? You do have to explain to someone at the end of the day, your CEO, your board, your shareholders, why you are spending $1 million, $2 million on attorneys a day to try to get to this resolution. Obviously, the numbers eventually get, but at the same time, it does get to a point where by the fifth quarter, you're explaining why we lost some income that we were getting under the old license. You're going to push discussions regarding maybe lowering it just to get, just to stop the spend and get some income, and that's the tough part.
Yeah, and maybe Micky, you could just quickly talk about the anti-suit injunctions and how different jurisdictions are trying to play off each other.
Yeah, so I think it's a great question in terms of, does a court in one country sort of listen to the decision of another country? And as it's hard not to think about this in the context in our global issues around the world in terms of how we are getting more extreme in one way or the other, right? And there's, I think, kind of a backdrop of nationalism that comes across on this, where perhaps courts were a bit more accommodating for the decision of one country versus another country, and that happening less so as time goes on. So, this slide, kind of an example on the right side there of a number of multi-jurisdictional suits where a court in one country had one decision and a court in another country sort of came up with a different conclusion. And I'll talk a little bit about Microsoft Motorola since I was directly involved in that one. This was when Motorola was an independent company in 2011 and had sued on Wi-Fi patents and video coding patents against Microsoft's Xbox and got an injunction in Germany. So no Xbox consoles in Germany as of a certain date. Microsoft goes to a court in Seattle, Washington, home court, and gets an anti-suit injunction in place where the judge said that the amount that Motorola is asking for is not FRAND. And therefore, Motorola, you are forbidden from enforcing the injunction that you have in Germany. And went one step further and said, here are the rates that we think that should apply for your Wi-Fi patents and your video coding patents, which turned out to be really modest rates. Another piece that is important that happened through there is in the process of that case, from the time it was filed to the time it was resolved, is that Motorola was purchased by Google. And so this effectively became Google versus Microsoft, where Google is the plaintiff enforcing the rate and Microsoft is the defendant. Those of you who know Google's views on patents and policies, it's more aligned on the implementer side. So in essence, you had two companies fighting a lawsuit that were on the same side of the issue at the end, and resulted in much more favorable rates associated with it. But this is spilled over at Huawei Conversant, courts in China versus courts in the UK, Continental Nokia's, courts in UK versus courts in the US, Xiaomi Interdigital, courts in China versus courts in the UK and Germany, Oppo Sharp, similar, courts and finally Samsung Ericsson. And I'll walk through Samsung Ericsson a little bit just to give you a sense of what's involved. And I have a slide here on the next one, I think, that walks through what happened through the winter of...
Yeah, maybe we could just cover this real quick to show kind of the ridiculousness of it. And then I'd like to get to the kind of concluding slides since we're getting close to the end.
Sure, yeah. So I won't walk through all this, but you can see there's a number of events. So this happened from December of 2020 to January of 2021. So we're only talking about a period of time that's like 45 days, right, or something along those lines, barely a month. But Samsung, first of all, a Korean company, right, files for a judgment in China. And Samsung, by the way, has little to no market share of product in China, and asked the Chinese court to determine what the global FRAND rate should be, and did not tell Ericsson that they filed this case. On 4 days later, when a prior agreement expired, Ericsson sues Samsung in Texas for a breach of FRAND. And you can see there's a number of things over the course of the dates, and I won't go through each one, but basically what happens is the court in Wuhan says, yes, we will determine what the global rate is. The court in Texas says, no, you won't, and files an anti-suit injunction. This goes one more round with Ericsson asking the Wuhan court for a temporary restraining order. Ericsson sues in a number of other countries. Eventually, Judge Gilstrap, the Eastern District of Texas Court, orders an anti-injunction suit ordering Samsung to take no action to the Chinese decision. So, and this, you're seeing this play out from an anti-suit injunction to an anti-suit injunctions. There's been examples of threefold anti-suit injunctions, and it really has gotten to the point of ridiculousness. The German courts have now decided, saying, hey, if you file an anti-suit injunction in any country, we're going to determine you to be an unwilling licensee. Just the act alone of filing it will be determined as an unwilling licensee, which then allows for greater injunctive relief and remedies in Germany. So some think that decision might stop the madness, so to speak. But for now, it sort of continues, including some of the cases you're currently involved in, anti-suit injunctions in the Apple Ericsson case between Colombia and the US.
Great. I'd like to move to our concluding slide here. Touched on a few of these issues. You know, is there a better way to resolve this? You know, as was asked, maybe, but, you know, what's fair? Is it, you know, who's going to be the central ruler in deciding what's a fair and reasonable and non-discriminatory rate? And does that rate, is it fair to have one person decide that and then apply that rate to the US as well as to like Colombia or Brazil, or, you know, are there other considerations in each jurisdiction that should make that rate different? You know, questions to be answered. So maybe we could just move to kind of what I want Luis and Carlos to talk about to conclude here is how can other attorneys here in the ASIPI regions get involved in this highly interesting, highly lucrative area of IP?
Thank you. I think, you know, a lot of people have asked me, why Colombia? Right? What was special about it? What did you sell? I think it's important, or this, it was important to sell your jurisdiction, right? Brazil's, I mean, I think it's a great selling point for Brazil. It's huge, right? We're not huge. We're like a fifth population and about a tenth of the economy. What we are strong, and I asked a lot of Colombians and they didn't believe it, but we do have a good judicial system, especially for IP. The procedure is designed, I think, to protect IP. We have a preliminary injunction procedure, which is ex parte. We have an extremely strong presumption of validity. We have extremely broad discovery, which I think people don't use enough, which is not relevant for this particular case. But there was the availability of an efficient solution for patent owners, including SEP owners. So I think talking about your jurisdiction and why it's useful to protect rights in general, I think is good. I think most folks do that. But I think in patent and SEP litigation, that's particularly important and viable. So I think that that's a key aspect. That's something important you need to do. The other things too is, just very quickly, is you have to take into account, who you're going to represent. Conflicts start to become more important, right? Do I want to touch Apple? I already took that decision in my life. I will never represent Apple. That's obvious, right? But that's something you need to think about. I'm not going to represent Apple in anti-counterfeiting. I'm not going to do their prosecution, but there's other options. The other attorneys will take those same decisions. Those are things you need to evaluate as well. And third, I think is selling your jurisdiction. I mean, do you want your jurisdiction? And many times it's just an issue of researching it adequately and selling it. I think you need to go out there and tout that a little bit more.
Luiz, would you like to add anything to that?
Yes, I think that we'll see more and more of these cases probably to come your way. In Brazil, we have had for years now these litigations and similar issues, and we have a number of actions that are taking part. But I see that recently in Brazil it's changing, and Brazil is becoming more and more part of this global jurisdictional disputes. And this is increasing. And if you look at what's happening, it's happening more and more. There are two basic factors. One of these factors we have nothing to do with that and we cannot control. I mean, like the market, the size of the economy, the way the courts deal with the issues. That's very hard, I mean, in terms of us to control. But there are things that we can certainly, for other countries within the ASIPI region, try to promote. And I think if you want to participate in these disputes in the future and be a favorable jurisdiction, some of these issues have to be addressed by you in your countries. In Brazil, we have a court system that is extremely patent owner friendly. We have a very strong court system, a very strong system of preliminary injunctions. We have specialized IP courts in São Paulo and Rio and Porto Alegre and in many other jurisdictions, now Minas Gerais. All these different states are starting to have specialized courts. Brazil has a system where invalidity is discussed in the federal courts and infringements in the state system. But in both courts, now we have been seeing the specialization of the courts. And in our firm, and also in many in the Brazilian Intellectual Property Association and other associations, we have been promoting this specialization. We have been promoting the improvement of the laws or improvement of the praxis. Right now, I'm extremely involved in having an IP specialized court of appeals in Rio. In Rio, the trial courts are specialized in IP, but when you appeal, the appeal can go all to different chambers, and for people that deal with family law to whatever. Now we are going to have 2 specialized chambers with 16 judges to hear business law and IP. And we've been promoting that, we've been supporting the courts, we are in contact with the courts, we are suggesting names of appellate judges to seat that are specialized in IP. So this is a kind of thing you can do in your country through your local organizations to try to promote more specialization. At the same time, we had, as you know, we had for many, many years a big backlog problem with the patent office. There were 200,000 applications sitting there in the backlog for decades. So within our efforts, and of course it's not only the efforts of our local associations, but we did work with the government, we did press the government to come up with solutions for the backlog. And the current federal government in Brazil did work a solution, a reasonable solution, very decent, not ideal, but very decent. And in a matter of 2 years, the government was able to examine and solve all the backlog in Brazil that had been for 20 years pending there. And this promoted many of these litigations, because you have to have a patent in the first place.
Exactly.
So these are things you can try to do, and I have to emphasize one point that Carlos made, and you have to promote your countries through newsletters, to information to your clients, to information to the market, that you have in your country an environment that it's good for the enforcement of patents.
All right, we have 1 minute left. Any final questions? Still more chocolate here. Yeah, 48 seconds. I got 48 seconds. All right. Well, thank you everybody for your attendance, and thank you for having us. We really appreciate it. And any of us are available anytime today or tonight if you have other questions you'd like to follow up with us on in person. But thanks a lot. We appreciate it. And I have to say, this is my first ASIPI. It is awesome. One of the best IP conferences I've been at. So thank you for having me.